Good evening and welcome to this session of the live learning classes conducted by the Board of Studies of the Institute of Chartered Accountants of India. It's nice to see so many of you. I don't see many of you here, but then there are a few of you here on a Sunday evening, eager to learn. And today we will go through, just give me 1 minute. Today we will go through, continue with our topic on prospectus. Before I begin, let me, as usual, invoke the blessings of the Almighty. Sahana bhavatu, sahano bhunaktu, saha viryankarvavahai, tejasvinavadidhamastu, mavidvishavahai, om shanti shanti shanti. Great. So, today, we will continue with our topic. Okay, a lot of people have come in. Good. So, we will continue our topic on prospectus. And I think I have a few questions. Let's see if I can answer them. Tanishka says, please explain 2 conditions of deemed. Madam, last class, we have not covered deemed prospectus or Nash versus Lind. So, I will definitely do that. In fact, we are going to do Nash versus Lind today. Okay? Or I'm not Nash versus Lind, deemed prospectus today. So when I'm doing deemed prospectus, I'll definitely cover. Okay? No problem. It's the last class we only saw up to here. Today we are going to start from deemed prospectus. Today we are going to start from deemed prospectus. And I would like to especially thank Miss Jennifer for giving me a nice word, especially that she's from Coimbatore. But then I was in Coimbatore, now I'm back in Chennai. So I keep shuttling between these 2 cities. And so right now I'm in Chennai currently. Right. Now, what is this deemed prospectus? By now, you are quite familiar with the concept of deeming. So deeming, D-E-E-M-I-N-G, deeming means creating a legal fiction, creating something which is not there through law, making something which is not there as real through law by saying, hey, legally this is it. Even though this is not so normally, factually, legally we are saying this is it. That's why it's called a deeming fiction or a legal fiction. Legal, L-E-G-A-L, legal fiction. Fiction means something which is not true, meaning something which is not real. I would rather use the word real. When there is a story about characters who are not real, we call it fiction. So legal fiction means a fiction created by law. So the whole purpose of this chapter, on prospectus is to ensure that when any document, circular or notice is sent to the public, it should be in a certain format. So 26 was all about that. We saw 26 before 25 for obvious reasons. So 26 was all about that format. So 26 clearly told you about consent, about who is an expert, and how it should, and the format should be as prescribed by SEBI, blah, blah, blah. Which means any document which is trying to offer securities for sale to the public should be in the format given by the government, which is the format given by the SEBI. Correct. Having said that, it is quite possible that some people may try to do some, the minute you make a law, there are people who want to circumvent that law. Circumvent means overcome, avoid, plan, all that. So, how is it possible? What they say is, a document containing offer of securities for sale is to be deemed a prospectus, provided the intention of the company, see what I'm trying to do here, I'm thinking. I means the company promoters and directors, they're thinking. Very intelligent people. What they think, hey, only if I give a notice or circular, it will become prospectus, right? Only primary. See, only when I'm going to allot these shares for the first time to somebody, the public, it becomes a public offer. Am I correct? I will not do that. I will first allot these shares to somebody. Usually this person would be a merchant banker or a investment banker or somebody with a lot of money. What that guy will do is, they will take the entire shares. They will take the entire shares. So the first time the allotment will be made to them, not to the public. Then this guy, this issuing house, this merchant banker guy, this big shot, this company, this fellow will send letters to people, public, wherein he will say, hey, buy the shares of this company. This is good. That document, that letter may not comply with the requirement of prospectus. And they will say, hey, you said only if the company does it, it's prospectus. The company is not doing it. I am doing it. I am only allottee. I am an allottee. I am a buyer. And after buying it, I am sending a circular to everybody. What's your problem? Now they are saying, in case any document containing an offer of securities for sale is sent, it will be deemed to be a prospectus, because it is not a prospectus, but it is deemed. It will be treated as if it is a prospectus. It will be treated as if it is a prospectus. When provided allotment of securities by the company is made by a company with a view, means with the idea, with the thought that all or any of those securities will be offered for sale to the public. So the intention of the company, the mindset of the company at the time of making the allotment to this entity, the intention was not to allot to this entity, but that these securities will be ultimately offered to the public. All that is fine. I have said it, you have accepted it. Now, how to believe? Who knows it? Intention is in the mind, Baba. Sochana. It is in the mind. Thinking is in the mind. How do you know what I was thinking? I allotted, he took it, then he offered. How do I know? So how to know the intention? How to say, this is the intention? There they have a presumption. Boss, you allotted to him now. At that time, when you allotted to him, we will see what happened. There is a presumption that those shares will be eventually offered to public. There will be a presumption. One second. Gunjan, Mr. Gunjan Kumar, please take your Institute Board of Studies material. It is there. Yesterday I explained definition of prospectus. Please don't ask basic questions again in the middle of the class. Don't interrupt. Prospectus, yesterday, the last class we saw, any notice, circular or anything sent to the public offering shares for sale. For your sake, I'm repeating it, Gunjan. It's a very simple thing. Prospectus, see, you go to a Gunjan, you go to a, I know I'm able to see that you are not able to understand. I will again explain. See, forget all this. All of you just listen. You people go to a college for admission. What they do? They give you a prospectus. What is that prospectus? It tells you many things about the college or the school. And it also says this is what we are doing. Finally, it also gives you the fee structure and all that. Now, that document is called prospectus. Now, same way, company is going to the public with a letter saying all this. We are doing this, we are doing that. Finally, they are saying we are selling our share. This is the price. How would the valuation? That document, that paper, that notice, that circular. Are you able to understand, Gunjan? That is called prospectus. That is what we are studying. This topic is about that. Are you able to understand? There are some strict rules by the company law on that document. That is what we have studied. Section 26, format, signing, expert, consent to be given. All that we have seen. Now we are only seeing deemed prospectus. If you have understood, just confirm to me, sir. Okay, everybody. That's why I use the word not college. I use the word institution. Okay, all So again, I'm only giving this as a comparison. Don't immediately compare one and one and say, sir, institute prospectus may say, but whereas in our, this project, it's not like that. I'm merely giving a way for you, because you're not able to understand complicated things. I'm giving a simple way for you to understand what is the prospectus. It is a document given to the public for promoting or selling something. It could be the school, college, institution, or it could be the shares. Whatever it is, and in that background, okay, Mr. Gunjan, have you understood? Yes, okay. But also, those of you, just concentrate on what I am saying. Then you will be able to understand it better. I'm using very simple Asan English only so that some of you will understand. So kindly listen to me carefully. And I interrupted my class for answering Gunjan because suppose Gunjan doesn't know what is prospectus, how he will understand deemed prospectus? That is why I explained what is prospectus. Now, what in our case, what I'm saying, instead of the company giving the offer to the public, that letter to the public, they are allotting the share to some XYZ, somebody. That XYZ, who is the allottee, who is receiving allotment of the share, they are sending a letter to the public. So they can argue now, hey, this is not given by the company, so definition of prospectus won't apply. That is why in section 25 they say that document will be deemed to be a prospectus. But only if you are able to show that the intention of the company at the time of allotment was that it will be eventually, ultimately, finally offered to the public. Eventual means finally, ultimately, the purpose of this is to offer it to the public. In between, we are allotting. So that allotment will be ignored. So, and say, but it's not invalid. They are saying, I don't care. Any document you are sending is as if the company is sending. So it should comply with the requirement of prospectus. So how will I know the intention? So there they say, there is a presumption about it. If it is shown or if it is clearly established that two things, please understand, two conditions are prescribed. The word used here is or. Please understand. Whenever the word used here is or, then even if one condition is satisfied, then you are caught. Even if one condition is satisfied, you are caught. If suppose the word used here is and, then both have to be complied. For small company definition, you can go back and again see my slide, which is there with you. For small company, the word used is and, which means both have to be satisfied. Whereas here the word used is are. It means even one condition is satisfied, it is okay. So, or. So that means, first condition, the offer for sale to the public by that entity, the allottee. See, the guy to whom you made the allotment is making an offer for sale to the public. That offer for sale was made within 6 months. 6 months after the allotment. So, the company allotted shares to this gentleman or lady or company. Then within 6 months, they went for allotment. They went for sending an offer for sale. So the idea was simple. I will allot, immediately you will offer it to the public. So what is that reasonable period? They are saying 6 months. So if the offer is made after 6 months, no problem here. But if the offer is made within 6 months, sorry, the assumption is, the presumption is that your intention was to make it to the public. So the company's intention was that this allottee will make an offer to the public. That was the idea. How to know if that offer is made within 6 months after the allotment or agreement to allot? It need not be allotted. There could be an agreement between the company and the allottee to allot. Agreement also is okay. Right. B. Another condition. Even if this condition is satisfied, the section 25 will apply. That at the date when the offer was made, the whole consideration to be received by the company in respect of the securities had not been received by it. Means what? The company, suppose the offer is, the share value is 25 rupees, 10 rupees face value, 15 rupees premium. Now, at the time of allotment, They have not paid the money. Now the offer is being made. Let us say the offer is being made after 6 months. Still, the offer is being made after 6 months. Still, suppose on the date of that offer, the company has not received the full consideration. Suppose on this 25 rupees, that fellow has only paid 5 rupees. Balance 20 rupees is to be paid. Then he will pay. He will collect it from the public and pay. That means the intention is to offer to the public. Please note, if A is within 6 months, B need not be 6 months. It can be 9 months also, within 6 months later. Okay, but still, on the day when the offer is made, you have to ask the guy, hey, have you paid the entire money to the company? Or better, you ask the company, have you received the entire money from that bugger? No, we received only 5 rupees. Then, even though it is after 6 months, still that offer will be treated as a prospectus, deemed to be a prospectus. Okay, friends, I'm giving my best explanation of this. But this what shall I say, flow chart could also help you to understand it better. Okay, so look at it. In this flowchart, what we are doing is we are looking at the two conditions. See, so let us say that you are the Ministry of Corporate Affairs. You are the regional director. You have received a complaint, or you feel that an offer document has been sent by an allottee. Okay, you want to punish them under 25. You are the ministry. You want to punish them under 25. When you can catch them? Only if you are able to bring them within section 25 framework. So first you call that guy and ask him, has the allottee sold shares to the public within 6 months? So you find out what is the date of allotment or agreement to allot. When was the offer made? Date. Easily you can find out now from the date of the offer. Date. Is it within 6 months of allotment or agreement to allot? Yes. Then straight away it is a deemed prospectus. That's all. No. It is made beyond 6 months. Then you have to ask another question. Has the allottee paid full consideration to the company before offer for sale to public? If the answer is, has the allottee paid full consideration to company? If the answer is no, then it is a deemed prospectus. But if the answer is yes, yeah, they have paid the full consideration. It is within 6 months, full consideration. Okay, then not yet. So even though it is within 6 months, if the allottee has paid the full consideration, doesn't matter. It is not a deemed prospectus. But if it is beyond 6 months and also the allottee has paid full consideration, has not paid full consideration, then straight away. Okay. Suppose the allottee is selling it beyond 6 months, then you will escape and you will come into the second category. That is why that longer yes loop is there, which means the minute you say it is beyond 6 months, even if full consideration is received, it doesn't matter for me. Straight away you go to deemed prospectus. But suppose you say, no, beyond 6 months. Then you ask, have you paid full consideration? Yes. Then, go. Even though it is within 6 months, you are not a deemed prospectus. But if you say no, then you automatically become deemed prospectus. Got it? Okay. So, you have to answer no and yes. Not within 6 months, full consideration. Both have to be negative. That is, I have not made it within 6 months and I have paid the full consideration. Then not a deemed prospectus. Even if you answer to one negatively, then you're out. If you say yes within 6 months, gone. Or if you say, yeah, it was not within 6 months, but I have not paid the full consideration, then also it will become deemed prospectus. Okay. So this PowerPoint presentation, if you want, you can take a photo, or it's going to come to you anyway. You can keep it in your mind and you can use it in this. Now, what happens if a company issues a deemed prospectus like this? That format, that document will have to comply with section 26, provision section of section 26 as to content of prospectus, etc., completely will apply to this document. So you can't write all statements like wonderful company, no. You have to give all the relevant facts, material. SEBI ka guideline hai, risk factors should be told. Everything has to be given. So, one thing I'll tell you, this section 25 is not a new section, 2013. No. In the old law, as early as 1960, this section was introduced. In 60, now it was called 64. Section 64 of the old law, it has been there. This is not something new. This has always been there from beginning, because this deeming is something they want to catch at that time itself. So they have introduced. So 25 is not a new section brought about in the new law. So part and parcel of the old law. Earlier it was called section 64. Now it has become section 25. Right? So in addition to the normal requirement, of prospectus, Mansi Gupta, I'm going to ask you to do one thing. I'm not going to answer your question for deemed meaning. I'm not going to answer. I'm just going to ask you to do one small thing. Go to the Google. Just put the same, whatever you put here, put in Google. Deemed meaning, you will get it. Because I have given deemed meaning easily 15 times. I have told what is deemed, legal fiction, law creates fiction. I have told. Maybe you are not able to understand in English. So my suggestion, you just put deemed fiction in Hindi, you will get it in Google. Sorry, I'm being very frank here, because I just can't waste time again and again explaining the same thing to you. Simple. You just go to Google, put legal, put deemed meaning. Even if you want in Hindi, you put, or whatever language you put, automatically Google will give you. I have given you in English. It's a legal fiction. It is as though something is not so, the law is telling that it is so. Okay, we already saw deeming. Constructive notice we saw. Okay, deemed notice. Though actual notice is not there, though the knowledge is not there, it will be presumed to be there. Okay, so I have explained to you. Anybody, who is allottee, anybody. See, the idea of this section is somebody may circumvent. So allottee could be anybody. It could be a person, individual, or a company, whatever. The idea is, I allot the shares to somebody. That person sends a letter, whoever it is. That allottee could be anybody. But mostly, this case, the allottee would be a broker, or an issuing house, or an investment banker. Some financially sound body, they will take it up and they will do it. Okay. I don't know why Anmol Patwa is continuously typing blanks. I don't know what fun he is getting by doing it, but don't do it, Anmol, please. He is asked one question, I saw that. If within 6 months, but not paid full consideration, Anna, this flowchart has very clearly told you, Anna, if within 6 months, straight away go, deemed prospectus. If within 6 months, but paid full consideration, it doesn't matter. You understand? In this chart, you don't think it is not there. It doesn't matter is the point. Anmol, listen to me. Don't try to bring everything into this chart. There is no need. If within 6 months, whether the consideration is paid or not, doesn't matter. Straight away, you see that yes, now. You see this, yes. That is the point you have to remember. Okay, by doing what you are doing now, you'll only get confused. In this case, it doesn't matter whether the consideration is paid or not. Because even this one condition is triggered, now straight away it becomes deemed prospectus. But in case you say not within, then only we go to this point. There again, if you're saying we are not paid, then it becomes a confirmed deemed prospectus. Even if one condition is satisfied, it's enough. Okay. If you are able to understand this, I'll be much obliged and happy. But if you're still going to keep worrying why this, can I change it, please sit calmly in one corner of your house, change it. Try to make it the way you want. But this slide works well. If you understand the simple point, it is enough. The minute you say it is not within 6 months now, it doesn't matter whether the allottee has paid in full or not. You understand? So if within 6 months, okay, and the allottee has paid in full, then then also deemed only, na. What you got it? It's already deemed, double deemed. Anmol, got it? Okay. Thinking is good, but thinking too much is bad. Okay. Thinking is good always. I like students who think. But thinking too much is a danger. Huh? So this chart is clear and unambiguous chart. Use it. If you feel this is wrong, don't use it. Period. That's easy. Don't use it. You create your own chart where the deemed but not will come. You put arrow mark here, there, and all. You put that is your choice. There's no need for it. Because once one student kept on confusing me in one early class. Even I got cheated by that student's view and I tried to create a new chart and all. Then I realized, hey, what nonsense. This is the correct chart only. Okay. Chalo, going on. The net amount of consideration received, or see, in addition to the requirement of the prospectus, in addition to that, the net amount of the consideration, in addition to the other matters, in addition to that, this deemed prospectus should also state the net amount of the consideration received or to be received by the company in respect of securities. See, this had an advantage. In those days, there was a possibility because in those days, they used to issue it at a discount to the issuing house. See, the idea is simple, ma. I am a big broker. I got a lot of money. So I come to you. You are not able to, you need money very fast. So what I do, I give you the money straight away. I give you the money straight away or I give you 50% straight away. 10 rupees share you give me. 10 rupees you give me 8 rupees. I take it at 8 rupees. Then I offer it to the public at 10 rupees. I get 2 rupees on it. Sure. When I offer it to the public, I make all sorts of claims and all. So to prevent this only, they are put deemed. So it is quite possible that, see, you are doing it beyond 6 months, full consideration has been received. Then that letter is not deemed. But suppose it is within 6 months, etc., then what you have to do? In that document, along with prospectus, you should also mention what is the price at which the allottee is getting it. What is the consideration received or to be received by the company? So let us say that the valuation of that company is 650 rupees. 650 is the correct valuation, around that. But this allottee is getting it at 600. So he's got 50 bucks. So once I'm reading the prospectus, yeah, this guy is getting at 600, I'm getting it at 650. I know. Oh, so there's 50 bucks in it for him, like that. The time and place at which the contract whereunder the said securities have been or are to be allotted may be inspected, if at all there is any agreement by which the company, because see, all these are commercial, so mere word of mouth is not enough. So the company will enter into a contract with that guy. So see, nothing wrong in doing this, provided, see, there are many cases where some fund houses and all, they will give the entire money to the company and wait for 6 months, then go for it. Or they may go within 6 months. If they go within 6 months, then they have to comply with prospectus. If they do that, they should mention all this. Okay. But ideally, what they will do now, they will give the money, then they will wait for 6 months and then they'll pay the full money, then they'll go. Nobody can tell anything. They will send a letter to their clients and customers that need not comply with prospectus. Okay. In case that allottee is a firm or company, the said document is to be signed by 2 directors or not less than 1/2 of the partners, as the case may be. But even if before you ask me, even I have a doubt, because now, see, my understanding is a firm cannot be a member of a company in its own name. Friends, I repeat, a firm cannot be a member of a company in its own name. But partners can jointly hold shares. Partners can jointly hold shares. Okay. Now, so when partners jointly hold shares, they can, it will have the color of firm property in the firm's accounts. But as far as the company is concerned, it cannot enter the name of a firm. Only the individual 2 partners, 3 partners, their names will be entered. So then the allotment will be made to the firm. But then the firm can never be a member. Only the partners will be shown as members. In which, if that is a firm, then that is how I'm understanding this. Normally, a firm can never become a member of a I'm again and again repeating, very carefully I'm using my words. A firm cannot be entered in the members register, the name of that firm, because firm is not a separate legal entity. It cannot hold assets in its own name, even if it is registered. Even if it is registered, any asset, even if registration is done in the name of the firm, it is a joint property of the partners. The firm cannot sell directly. Okay. That is why when you are buying a property from your firm, you have to be very, very careful. If one partner alone is signing, no, sir, ask all the partners to sign, or get NOC from everybody, then you come and sign. With the power of attorney, you come. Okay, that's what, because tomorrow any one partner can come and make a claim. Now, here is a practical question for the purpose of testing you. You can have a look at it while I read some of the question. That could be also a correct way, Ruturaj is correct. Here the word firm could mean a limited liability partnership, because LLP can be, could be. Even I'm saying, no, I'm not saying, can the firm never buy shares in a company? It can, but it cannot be held in the name of the firm. It could be LLP. I totally, LLP is also a firm only. Limited liability partner. Agreed. Good point. Excellent, Ruturaj. Thank you for that. Good input. Ankur Patel, what is he saying? Six months is from the date of allotment or from the 6 months date of allotment? Date of allotment. That's how I have always understood it. I don't think it's from the end of the month when the allotment was. I don't think it is so. Unless you have some other information to the contrary. Let me check up. Within 6 months of allotment. Or in case there is an agreement to allot, within 6 months from the date of agreement to allot. I don't think there is any confusion there. If you want to be confused, you can. But there is no. 6 months from the date of allotment. You can count 6 months now from that date, not from the end of the month. No. Ankur, I have answered your question. And now you confirm that you have understood. If the person to whom company allot shares and he make offer of sale for, then people who buy shares, shareholder, they are. See, brother, if I allot shares to you and you sell it, the person who buys from you will be member or not. They will be member only. Okay, they will be member only. One more point. I think I will understand your question in a different way. Suppose this allottee has given a deemed prospectus. This allottee has made a deemed prospectus based on which allotment has been made, based on which transfer has been made to some people. Whether they will get title? Yes, they will get title. They have not done anything wrong. In fact, if there is, they can also file a suit against these people because they have relied on a document which is not clear. So if there is any false statement, they can file a suit against everybody. The allottee, the company, everybody. Okay. But the allotment is valid and the subsequent sale by the allottee to the public is valid. That cannot be taken because otherwise, what is the idea here is to protect the investors, not to protect the allottee or the company. Okay, so good. Pooja, why I am laughing, your knowledge you want to display here. But in this context, what is the use of that point? Because I agree, Section 8 company ka shareholder, you can be a firm. But can a Section 8 company issue a prospectus? What to do? Correct. Firm can become, that everybody knows, yeah. I totally agree. But in this context, it is not. Okay. Anyway, no problem. Your knowledge is appreciated. Your knowledge is appreciated. The fact that you are able to remember That Section 8 company firm can become, I'm happy that you remembered. In this context, it makes no sense. Anyway, read this problem and try to give an answer. See whether both the conditions go by the flowchart. Capricorn Limited allotted 10 million shares of rupees 10 each to Silverton Financial Advisory Services Private Limited at a premium of 25. So totally they have to receive 350 million. Okay, this was done. The allotment was done on 5/2/2020. 5/2/2020. Capricorn Limited was paid the entire consideration of 350 million on 15/2/2020. Okay, so 5/2/2020 allotment, within 10 days, 15/2, entire money was paid. Now Silverton Financial Advisory Services made an offer of shares to them, to the public, on 1/8 by sending a letter of office on their letterhead, making tall promises. Tall promises means not true, untrue. Tall promises is a nice English idiom of saying not true, false, like that. Making tall promises about the future performance of Capricorn. Future performance of Capricorn. Now, is this letter deemed to be a prospectus? So what you have to do, first condition, full money has been, you go by the first condition. What does the first condition say? 6 months. So 6 months, you see, when did they make the letter of offer? 1/8. So when was the allotment made? 5/2. So 6 months we have to see. So what? How to see 6 months? 3, 4, 5, 6, 7, 8. So when will that 6 months get over? On 4/8/2020. 4th August 2020, 6 months will get over. 6 months will get over on midnight 4th August 2020. Whereas when was the offer made? It was made on 1/8/2020. Means less than 6 months. So if you go by the flow chart, has the allottee sold shares to public within 6 months? Yes. The offer was made within 6 months. Straight away deemed prospectus. Straight away deemed prospectus. Straight away. You have to go to the next condition at all. But I'm asking one more condition. One more question. Will your answer be different if the offer is made on 15/8? Now what has happened? It is beyond 6 months. Now you have to verify. Have they received the entire consideration? They've received the entire consideration. That's it. So both the conditions are not satisfied. Therefore, if it is issued on 15 August, it is not a deemed prospectus. But it is on 1/8, it is a deemed prospectus. Okay. Correct. Gunjan Devi gives a nice answer. I will read it. That is a correct answer. So everybody who gave that answer is correct. Gunjan Devi's answer is being read now. Yes, it will be treated as deemed prospectus because there are some days left for 6 months over. Correct. Some days left. From 1/8, you have still the 2, 3, 4. 4 midnight only, 6 months will get over. So, but if offer is made on 15th August, then it will not be treated as deemed prospectus because it is beyond 6 months. And Gunjanji, add one more point. Beyond 6 months, and the allottee has paid the entire consideration before the date of offer. So 2, you have to see that also. Therefore, on 15/8, it is not a deemed prospectus. Okay, so with this, I think nobody can have any doubt. See, on page numbers, for the first time, I'm referring to your Board of Studies material itself. I am not reproducing it in my slider because it is there in your own material. Why I will reproduce it here? See, basic concept they are saying is, public, they are trying to say, it cannot, if some document is marked private and confidential, it will not become public. So that Nash versus Lind which was referred by one of our students in the beginning itself. First itself, she is asking, Tunishka, Miss Tunishka, that Nash versus Lind. So there is nothing. See, there was a man called Nash. Nash is the surname of a British man. Nash. You can see the citation there, 1929 case. Okay, Appellate Commission. It's gone to the appeal commissioners. Okay, that 158, 140 is the page number of the Court of Appeals. Then it goes to the House of Lords. Can you see HL there? It goes to the House of Lords. There in the House of Lords, it's 146. That is 140 volume, 146 page number. This case is reported. Very old case, 1929. So this guy Nash applied for certain shares in the company on the basis of a document sent to him by Lind, the managing director of the company. The document was marked strictly confident. The document did not contain all the material facts. But now, that is the point. It did not contain all the material facts. Means required by the Act. But Nash filed a suit for compensation for loss suffered by him. So that is why this is called Nash versus Lind. Nash files a suit. But that suit was dismissed. Then this guy goes on appeal to the House of Lords. The House of Lords also concurs with the view of the Court of Appeal. Why? Reasoning. What is it? Public. That is where the Viscount Summer, one of the members of the House of Lords, he is giving this view. Okay. Public in the definition is of course a general word. No particular numbers are prescribed. Anything from 2 means I am not, to myself, if I talk, it's not public. One more person is there, 2 public. Okay. 2 to infinity may serve perhaps. Even 1 if he is intended to be the first of a series of subscribers. But the point is that the offer is as such is to be open to anyone who brings his money and applies. But in this case, what has happened? Nash received a letter which was marked strictly private and confidential. It is not open. It is not to everybody. That is the decision of Nash versus Lind. Okay. Later on, when you come to see, that is why in our Indian, now in the Indian law, Companies Act, we have got private placement. Thereby, the law itself says, Baba, if you are sending up to 200 people, I have no problem. You mark it strictly private and confidential. Send it to 200 people. Beyond 200 people, if you send, it becomes public. So, Nash versus Lind in India, you have to be a little careful. In India, the word public. Are you able to understand, Tunishka ji? Nash versus Lind is an old British case where Viscount Summer was talking. Now, Abhi, what has happened in India, we have said up to 200, it is private placement. So, we have prescribed a number called 200. And in India, we are saying up to 200, if it is marked private and confidential, then there is no public offer. It is private placement. Rule of this won't apply. But the minute it's sent to one more, 201, it becomes public. So, we have prescribed a number for public, which is 201. Okay. Are you able to understand? When we come to private placement, you will see that number. Page number is 3.11, 3.10. Normally, I will not encourage referring to the Board of Studies material when I am taking the class. Today, I am using it only because I wanted to reproduce this Nash versus Lind in my slide. Then I thought, why the hell I will do that? That way, if I have to reproduce case laws now, I've got 40 case laws. I've got 40 different case laws and prospectus. If I display everything, you will go mad. See, friends, all case laws, whether they are relevant or not, no. I'll make a simple suggestion. Whatever case laws are given in the Board of Studies material, remember it. Chances are they will ask. So, if it is in the material, it will come. So, that is why I thought I will as well cover Nash. So, in Nash versus Lind, why the decision was against Nash? Because that document had the words private and it is strictly private and confidential. So, it was not intended for the public. Okay. So, suppose you write a letter to your friend. Okay. They will just saying, hey, I have purchased shares in Dubakur Limited. Wonderful company. The MD is a nice man known to me. It's a very, very, very difficult thing to get these shares. In case you want, I will give it to you. Private, and don't tell anybody. Then you read that letter. You send a letter back to him or mail to him saying, no, I'm interested in buying. How much should I send? You send. It's a private deal. Where is the public here? Are you able to understand? That is exactly what happened in Nash versus Lind. Additional matters to be stated is simply, I've already explained it, Baba. Don't make me cry. Okay, so read it again, you will understand it better. See, in addition to what is to be mentioned in section 26, this one. Case laws are important provided they are there in the institute material. Please read them and remember them. Okay, wherever a case law is quoted in the institute material, please remember it and try to quote it. Okay. I am not covering all the case laws mentioned in the material because they are there in the material. And if you know the principle of the law, which I have taught, that case law is not a big deal. But where something I have given extra is not in the institute material, you can even ignore it. There's no need for you to waste your time. That's why for exception to the doctrine of indoor management, I have about 10 case laws. Okay, including Mahoney versus East Hollyford Mining Company, which is the important case law in that. And under A.L. Underwood versus Bank of Liverpool, Howard versus Patent Ivory Company Limited. So there are so many case laws. If you like to remember, remember. If you don't want to remember, leave it. See, it's like this. Suppose somebody likes maths, they will read with interest. They will remember. Suppose somebody likes law, they will read with interest, they will remember. So again and again, I'm telling you, remembering is not about reading again and again or a thing. It is about liking. Once I like, my mind will remember. This is a simple secret of memory. So if you think, some of you would think your memory is not good, I totally disagree with you. You are not able to remember because you don't maybe like reading that subject. So develop an interest in the subject. The chances are mind will remember better. Also, in psychology, we have two types of memory. We have long-term memory and we have short-term memory. For law subject and all, what you need to develop is only short-term memory. Very important for you to understand. Short-term memory, which means it is enough if you remember it till the exam date. The brain has capability to remember short-term. If you put a little pressure on the brain and say, hey, I need to know this, it will remember it. And the exam, you will find it, you won't remember. Like that, many subjects I have done like that. Just for the exam's sake, I will do it. I will remember, go there, write, come out, I don't know. If you ask me after the exam, 2 days after the exam, everything will be forgotten. Okay? But that way you can use your memory. So it is in your control. Again and again, I'm telling. So case laws are important. From a law paper, in law, case laws are important. If you can remember, remember. If, okay, you cannot remember, I am unable to remember, leave it. Rather try to remember the content. Try to remember the logic. Try to remember something and write decent answer. You will get 50 marks now. 55 you will get. I want to get 75 in law. Then you should have interest in it. You should have. Once you have interest in law, automatically you will remember it. See, some of you may be interested in income tax, which means you will know even the smallest subsection of the section 14A, rule 8D, C, you will know. So that is because you like it. So that is how you have to. If you like the subject, see, I don't like income tax, believe me, but I know short-term memory. For the sake of learning my livelihood, I remember and I use it. Then I forget it. I remember Shakespeare, Milton, which I like. I don't use my brain to remember all this. And most of it, but short-term memory. So like that, you have to, even if you don't like it, develop a little bit of interest, which is why, because you people don't like to remember theory only, they have removed law from final. They have totally removed law from final and now you don't have to write that exam at all. Of course, self-paced, you will write it later, but that's multiple choice. You are, I think, I don't know, whatever. So, good. Now, we come to another important section. Now, this is easy to understand. If you remember memorandum, if you just throw your memory back, and if you remember, you people are all so intelligent. So, you should be able to remember. When we did memorandum, there we saw object clause. Any alteration in the object by a company which has raised money from the public. Do you remember that? A company has raised money from the public and amount is remaining unutilized. Amount is remaining unutilized. Such a company, it wants to amend its object clause. We said there is a special provision. You have to pass a special resolution for that and More importantly, if you do not if any person doesn't agree, dissenting, they have to be given their money back. You can't buy back. The promoters or somebody should pay them, and they should be given an exit option. Okay, so what was the basis for that? At that time, we said the doctrine of ultra vires. If you still don't remember this topic, no problem. After the class, you go back. You will find it in my slide. Okay. And when I taught that topic, I told you same concept will come in prospectus also. So basically, the idea is any funds which are raised from the public shall be used strictly in accordance with the terms contained in the prospectus. Meaning, see, I am the public. Doctrine of constructive notice is there. You issued the prospectus. I read the prospectus. In that prospectus, what you are telling, we are going to make electric vehicle. I like it. I like the project. I'm sure it is an up and coming latest technology, blah, blah. So I give my money. Now you guys are coming and saying, no, we are not going to use that money for making electric vehicle. We are going to set up cement plant. Huh? When you issued the prospectus, you didn't talk about cement plant, Baba. You spoke only about EV. Now suddenly, where is the cement plant coming from? For that purpose, you would have tried to amend your memorandum. That also you will get. Here again, you are trying to use the money for a purpose other than that for which it was raised. So funds raised from the public shall be used strictly in accordance with the terms contained in the prospectus. So whatever you said, correctly enough, see, when you take money from me, you tell me this is the purpose, I believe you. Now, quietly, if you change the purpose, then I would not have given the money, right? If you're trying to do any deviation means change, variation. So, prohibition on deviation by way of use of issue proceeds, okay, for investing in equity shares of any other listed company. So, you're taking this money and investing it in another listed company. I didn't give you money for investing in any other listed company. So, money raised by prospectus should not be used in that purpose. So, the legal principle involved is the doctrine of ultra vires. Whatever you stated in the prospectus is the binding, is the scope. Beyond that, you cannot go. The same doctrine of ultra vires means beyond the powers will apply mutatis mutandis. It's a Latin term, meaning with suitable changes, with appropriate changes to this situation also. Whatever you apply to the memorandum, same concept will apply to any statement made in the prospectus also. Now, so if you are going to use the money raised through the prospectus for investing in the equity shares of any other listed company, not possible. Friends again will note, they are only prohibiting investment in any other listed company. So, boss, it's quite possible that you are going to raise money from the public, the parent company will rise. Then, for the purpose of manufacturing EV, we will form a subsidiary, unlisted. Public company, unlisted. Now, I can invest in that, no problem. This company can invest its money in that unlisted subsidiary, we can make it a wholly owned subsidiary. No problem. But suppose you raise money from the public and say, I'm going to invest it in Reliance Industries Limited. Hey, if I want to invest in Reliance Industry, directly I will invest there, Baba. Why I will give it to you? Are you a mutual fund? Like that. So there is a prohibition on using the issue proceeds for investing in the equity shares of any other listed company. Okay. Now you are saying, no. We all honestly wanted to manufacture EV, but now we feel it's not good, but we see there is a good opportunity for cement. So we want to put up cement plant, or we want to put up something you are saying. Maybe you are right, because ultimately, boss, the shareholders, the public, if they know how to make money, why they will invest in company? They will do business now. Instead, these fellows are working in bank, working in insurance company, chartered accountant, finance, operations, whatever. They are all working, getting salary every month. So if they know how to make money, then they would have done it. So they don't know. Whereas you are a businessman, you are an entrepreneur. You know the pulse of the market. So we trust you. So if you come back to us and say, boss, you know what? We thought we'll do EV, but now there's a slight change in plan like that. Agreed. I believe you. You are Anil Ambani, you are Mukesh Ambani. I believe you. Okay. But there's a procedure for that. You can't simply decide in the board meeting and go ahead with it. You have to come back to the shareholders who gave you that money, and you have to ask them to pass a special resolution through postal ballot, right? Remember, now that you have issued the prospectus and made the allotment, you have become a listed company, right? Now, so if you want to make any variations in the terms of any contract mentioned in prospectus or object stated therein, to be approved by the company in general meeting by special resolution, possible. So you definitely want to move to cement manufacturing, no problem. If the shareholders agree, what is our problem? They pass a special resolution, good. Not only should you have a meeting, they want you to pass a special resolution, not at a physical meeting, but through postal ballot, so that, see, there may be shareholders who are busy. Poor fellow is working calm, so he has to go Monday morning till Saturday night he is working. How he will come and vote in your meeting? Yeah, so he should be given some opportunity now. So sitting in his office, he can fill up the postal ballot form, send it. Or even you can have electronic voting. He can participate through electronic voting, so that he can, if he doesn't want, he can say no. So if sufficient number of people say no, then special resolution cannot be passed. If special resolution cannot be passed, you know that, because of the definition of special resolution. Because if sufficient number of people vote against, then you have to multiply by 3. Number of votes cast in favor should be 3 times. It is not possible now. See, think about it. Suppose 40% of the paid up capital says no, then remaining is only 60 months. Was even if all of them vote for, still you need 40 into 3, 120. You won't get 120%, only 100 is there. So 40, you are getting only 1.5 times, whereas you need 3 times. 60 is not enough. So you cannot pass a special resolution. Got it? Okay. If you don't understand the special resolution still, don't worry. When we come to management and administration, again we will teach. Okay. But the definition is very clear. The number of votes cast in favor shall be not less than 3 times the number of votes cast against, if any. So take the number of votes cast against, multiply by 3, see the number of votes cast in favor. If this is more than that, if this is more than 3 times, special resolution passed. Okay. Details of variation to be published in 2 newspapers. There is English and vernacular in the city where registered office of the company is situated. Details of variation to be published in 2 newspapers. So the idea is, even people who are, they may not see the mail and all, they also will see the newspaper. The idea is to be sure that everybody is aware that there is a variation in the terms. Dissenting shareholders, that is those who do not agree, should be given an exit option. Exit option means the company cannot pay back. Any promoter or somebody should buy their shares, okay, and take out. They should be given an option to go out. Yes, they can invest in other unlisted companies. I did mention, you're not listening. I was giving an example of how they can. They can invest in unlisted. Public company also they can. Unlisted. Pooja, I'm not aware of the section number 1. You referred to my notes. It is there in the notes. You referred to it. It is there. You just go through the notes. You'll come up with it. Okay. I don't remember the section number. I don't have to remember, Baba. I am not writing this exam. You have to write the exam. Okay. So you have to remember. See, whatever money is raised, listen to me. I'm just explaining this point. Second point, money is raised by issuing prospectus from the public. That money cannot be invested in equity shares of any other listed company. Meaning, you cannot take money from the public by issuing prospectus and use that money to invest in another listed company. Okay. I gave the example. Now you take money from the public, then invest in Reliance Industries Limited. No, not allowed. I gave Reliance Industries Limited. You cannot invest in any other listed company. That's what it is. Anmol Patwa was asking the question whether you can make an investment in unlisted company. Yes, you can. Okay. Rutraj, that loophole, you are really great. I worship you, but let's not go into it. Rights issue and all, you don't know the reality of rights issue. Maybe when we come to 62 again, you understand what is rights issue, then you will know. Even then, first time I have to go public now. That if I go for rights issue, I will give to my existing shareholders and ask them to renounce. Now that is possible. But how much you can raise? You should. The problem is, I don't know what your background is, so I don't want to comment and get into trouble. Maybe you are a very senior person having a lot of knowledge, but it's not as easy as you think it is. This method of so-called loophole, I would prefer to go through prospectus and raise much more money. No problem. Going through the prospectus route is any day better. Okay, there's no need for a loophole here. Prospectus route is there. Okay, and that's a valid route. Okay, it is a good route. You go for listing, etc. Many companies will want to do that. Companies which don't want to go public, they don't need rights issue for raising, Baba. You got private placement. Later on, when you come to private placement, you'll see there is no need for this loophole itself. 200 people I can go and approach. Like that I can do again and again. There is no need for this loophole at all. So, just wait. And somehow, I'm not comfortable with these loophole things. The minute you go looking for loopholes, you get caught in that hole. This is my view. Please don't mistake me. I appreciate that your intelligence is appreciated. But good, but try to see these loopholes are always dangerous. See, you put a loop, you will strangle yourself in that loop. Don't do that. That is why, though I am a very core tax practitioner, 35 years I've been practicing income tax and etc., but I will never take pride in saying I do tax planning and all. And if my client comes to me, even if they mildly think, Mr. Srikanth, as a chartered accountant, we expect you to do tax planning for us, I'll say, get out. I am not here to do tax planning. I am here to advise you on the income tax law. I am here to ensure that you comply. Yes, I will see to it that you do not pay 1 pi more than you have to pay. But if your goal, my dear friend, is to do something, this, that, blah, 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 so that you will pay no tax, zero tax and all, maybe in this country there are 4 lakh chartered accountants. You don't come to me like that. You might be surprised when a man says this, he should not have a good practice. People should go, not really. I've got corporate clients, I've got large clients, I've got 100 crore clients, 1,000 crore clients, and all of them are only interested in complying with the law, and they respect me for that. They never will they call me, ask me, Srikanth, I don't want to pay tax. Tell me some loophole. Tell me some. Say, there are 100 chartered accountants outside the door here. Please go there. These fellows are specializing in this. I don't. Okay, so they think, no, Srikanth, okay, you ensure that we comply, that we grow, that we become big. Then you are with me. I can be your auditor. But simply if you want me to, because I have to keep on thinking how to cheat. That's not the way I have defined myself as a professional. Okay, so this is nothing to do with Rutraj's comment about it. Rutraja, absolutely no problem. Your intelligence is appreciated. In general, to you as students, I'm saying sometimes you will get this impression in the world that chartered accountant is meant for tax planning like that. That is the stupidest thing that the public think. Okay, they think chartered accountant means guy who will advise you to cheat the tax. No, sir, not at all. Okay, and you can play a very, very valuable role in society without doing all these loophole businesses. Okay, sometimes if there is a loophole in the law, remember, the minute that loophole is utilized 2 or 3 times, government will come to know about it and close it. So the window of opportunity will be open only for a short while. So if you think you can use it, but no great fun in that, ma. Okay, that is not how I get my excitement in being practiced. Okay. Good. Deviation, I mentioned that deviation, variation, change. Okay, changing your mind. Your boss, you are going on the road now. Suddenly you are going straight. They say, Deviation means what? You have to take a different route. So all along you're going in one route. Now you want to take another route. That is called deviation. No, sir, Mr. Manish Kumar. You can have subsidiaries. The money raised by public issue can be used for investment in unlisted subsidiaries. Even you can invest. Okay, I have given the answer to you, Manish. I have answered your question. Please, if you are not listening, I'm sorry, but I have answered your question. Now we move to offer for sale. Okay, I think section 27 is clear. Offer for sale. Offer for sale is similar to prospectus, but except that this is happening along with the public issue. Okay. Thank you, Nehaji, for that nice word. Now, I want to give a scenario. I want to give you a background so that you will understand this section. See, there is a company. It was started 15 years ago, 20 years ago by an engineer. He wanted to really grow this business. So he started running the business well. So every year on year, he bought in his own money initially, then relatives and friends. There is, close funding, then relative funding. Then after some time, he needed more money. So he went to the private placement route, etc. So some more friends and relatives, unconnected people, they also gave money through private placement. Now the company has grown. It's got 1,500, 2,000 crore turnover. So good capital base. So now this company's investment is there. Now, how is it comprised? The main promoter having 40%, main promoter and his relatives, 40%, friends and others, another 20. So totally 60% is held by the main promoter. Balance 40 is held by equity funds and all, QIBs, qualified institutional buyers, private equity funders and all come. All that was raised through private placement. So today I'm having promoter group, relatives, etc. Unconnected people, but friends of the promoter group is there. Employees could also be there in that group. Then you have the private equity funders, 3 categories. Now, this company is now ready and ripe for public issue. They are going public. So the minute they want to go public, they have decided. Now at that time, this gentleman, now 15 long years, the bugger has worked for this company. Literally 24/7, maybe a little time he had, but whatever money he earned back in this company. He is now 48 years old, 50 years old. The fellow says, enough is enough. I want to take some money out. Yeah. So he goes to the auditor and he says, what shall I do? So the personal auditor, the close advisor like me, I tell him, sir, you take some money out. See, today the valuation you have got is 450 rupees per share. When you invested, it was 10 rupees, 25 rupees you invested. So you take out. How Shrikant? How can I do it? We are going to the public now. We are going to allot fresh shares now. So how I will get the money? When I allot shares to the public, the company only will get money. How I will get? So he says, no problem, sir. Section 28 hai. You can make an offer for sale. Oh, really? How do I do that? Then we tell him, any members of the company, including promoter, anybody, may in consultation with the board means the board of directors of the company, board of directors of the company, offer their shares to the public. Meaning, let us say that this company is now going to go for a public offer, public issue. Public issue is what? 2 million shares. 2 million shares are being offered to the public. 2 million shares. Along with that, the promoter and maybe his friends and relatives, employees, etc., will also be giving a set of their shares. That is 2 million means these guys may give 500,000 or maybe 1 million shares. Together, mainly promoter will give. So all that money will come to them. Okay. At the time of public issue, there will be 2 documents. One will be a prospectus, the other will be the offer for sale. That is called OFS, offer for sale. It's an offer. So public will know that these shares are being sold by the promoter only. After all, what is there? 15 long years, 20 years, I grew this business. I'm entitled to take something out now. But I'm not taking the entire money out. Only a certain portion I'm taking. Now, recent example of offer for sale, which I come across in South is, there's a company called TVS Logistics. TVS, you heard of TVS, TVS Sundaram Iyengar and Sons, famous company in the South. TVS Suzuki and all is there. TVS, they have a logistics company. It was TVS Logistics. Then I think now it's something else. It's called TVS some other name. I think TVS Logistics. I don't know. They've changed their name to something, and I think that they were TVS Logistics. Now they've changed their name. Whatever it is, that company, when it went public, it also went for an OFS. Through that offer for sale, promoters, certain private funders, employees also, because employees were given ESOP and some employees were given stock options and they took it. So all that, and some employees simply purchased the shares from the company. They applied and got it. So they were all there. So that entire group, senior level employees, promoters, everybody went for an offer for sale. Okay. No big deal. The offer for sale will be in the same format as the prospectus. Same format, same rules, same risk factors, everything. The same price also. The public issue allotment, 450 rupees. This guy will also get 450 rupees. Only thing is, there is no allotment. There will be a sale. So, these people will transfer it to an escrow account. Then from that, the depository participant will transfer it. Once SEBI gives the approval, all these shares will be transferred to the various applicants who preferred the OFS route. So those who applied in the OFS will get that money. Okay. So that is how it is. Now, so this entire thing will be done by the company, by the board of directors. So all the money will be spent by the company only. But a portion of that is being money collected is going to the promoter now. One small, 2 million shares are coming to the company. 2 million into say 450 rupees. 20 lakhs into 450, you crunch the number. That amount is coming to the company. The 500,000 or 1 million into 450, it is going to the promoters now. So why should the company spend for them? Therefore, whatever is spent by the company, to the extent it pertains to OFS, will be reimbursed by the company. Okay, will be reimbursed by these members. Such members shall reimburse. How to calculate, boss? See, you are all already CA students. Yeah, you tell me 2 million, 1 million, so 3, so 1/3. So 1/3 of the expenses I have to give. Like that's some logic. Okay, if directly it is attributable to the company, chhod do. But if it is only relating to OFS, bring it here. Common expenses divide. That's all. See, once you become CA, you should know how to do this type of thinking. Simply like that, if you do, nothing can be done. You have to take a call. See, especially when you're sitting in the casting exam, if you simply, this was not taught to me in the class, what do I do like that? At that point in time, use your brain, because casting exam is a unique exam. No casting teacher can teach everything to you that in the exam hall, you will know it. The casting exam paper setter is a devil like me. He is trying to create a paper that is unique and original. So, he will set something. So, at that point in time, you have to think how to do this. Some logic. Common sense is enough. Logic. What is happening here? Hey, this is what. Chalo, this is what any reasonable person's common sense is, that will be the correct answer. Okay. Think from this. There's no need for any complicated knowledge. Maybe, see, once you become a chartered accountant, you will start using complicated words and terminologies and all. But bottom line, it's common sense. Okay. The document through which the offer of sale is made shall be deemed to be a prospectus. Again, deemed means what? It cannot be given on some way. It should also comply with the part 1 of chapter 3. Completely. 26. Everything will apply. Okay. Later on, we'll be seeing minimum subscription. Later on, when we come to allotment, we will see minimum subscription. That condition will also apply to this. So don't please put a question, what is minimum subscription? Don't write there. Please don't put, already I know you're typing. What is minimum subscription? Don't type it. I will explain to you minimum subscription. The word itself is clear. Minimum subscription. The minimum amount that has to be subscribed by the public for allotment. If that is not received, allotment cannot be made. Okay. So these conditions will be given in allotment, that will apply to OFS also. Suppose prospectus is given, OFS is given, applications are coming. Then you should ensure that the total size, in my example, 2 million public offer, 1 million offer for sale, total 3 million. Out of that, the 3 million minimum subscription should be received. Only then you can allot the shares. Otherwise, money should be refunded, which is why the money will be kept in a separate bank account under escrow. ESCROW, escrow. Escrow is a legal word, meaning any money or movable asset, it will be kept in the control of somebody, usually a bank. So that man will not release it unless conditions are satisfied. So once you produce that, they will release it. It's called escrow. Okay, it is there in many industries. For example, I don't know if you're aware, when a movie is produced now, the print will be there, the final print. That will not be released by the developing that studio, that laboratory which develops it until NOC is given. Suppose I am the lender. I have already lent money to that producer and he has not repaid. Now, I can go to the film chamber, I can go to the thing, get a letter saying, don't release the reels, don't release the film unless my money is given. So then it is held in escrow. It will be held in escrow by the laboratory till the money is repaid or some understanding is there. Then that will give NOC. Only then it will go. Okay. So like that, this is a legal method of controlling. So escrow. So the money received from the public will not be taken by the company or promoters till all conditions are satisfied. SEBI cleared. Only then the merchant banker will release the escrow to instruct the bank to release the escrow. Then the money will come to the company. Similarly, the DP will be holding these shares in escrow from the promoters. The minute everything is satisfied, the shares will be transferred to the applicants. Okay. Now, see, the prospectus is supposed to be given in the format of Schedule 2, in the format given in the by the SEBI. But some information will be available only with the company. Therefore, they should clearly state in the offer for sale document, these information cannot be gathered by offeror. And they should. Okay. So, also, who are the people bearing the cost of the OFS to be disclosed? Who are the people bearing the cost? So, they'll be giving a list of people who are making the offer for sale. Okay. Yeah, my suggestion, instead of me showing it to you and all, whenever you are free, Google for TVS Logistics and TVS Supply Chain Management Limited or something like that. TVS Supply Chain. Now it is called TVS Supply Chain Solutions or something like that. Just go check it up. You will see you can search for the prospectus on OFS. There is an offer for sale document is there. Okay. Now, why I am asking you to do it now? Suppose I show it here, it will be lengthy document and it will be waste of time. Now with this knowledge, if you go there, you read, you remember. This is one method of remembering. When you do it on your own, you develop interest. You will become interested. It's like that. Okay. So suddenly you will find you are able to understand. Also, many of the topics you are studying in intermediate will be very useful to you. This law topic now, whatever you are studying, especially share capital and debentures, accounts and audit and all, will be very useful to you in auditing paper also. In auditing also, you will find that this is useful. 1. 2, when you complete your intermediate, 1 group, 2 group, whatever, blah, you started doing your articleship or internship. If you don't like the word articleship, chhod dijiye. Internship with a big firm, big 4 firm, KPMG, Ernst & Young, Deloitte, like that. This knowledge will be very useful to you because they would expect you to know it. So there, if you say like that, they will think bad about you. So you have to know. That time they will assume that you know all this. Okay. Especially, you might go on an audit to some big listed company where the company secretary will be there, CFO will be there, even some 15 or 16 chartered accountants will be there. So when they are talking, they will be talking about all this, like that. If you look at it, then very difficult. So develop your knowledge for that. Okay. This is another section 40, which says, if you want to have your shares listed, if you are issuing a prospectus, then compulsorily you should have those shares. Those shares should be dealt with, meaning those shares should be bought and sold, or those shares should be capable of being bought and sold in a stock exchange. Okay. So along with the prospectus, you should also have made, please note, this is very, very important line. I'm going to read it. Remember it. Yaad rakh dijiye, please. Application shall be made to one or more stock exchanges and permission obtained for the securities being dealt with therein. Therein means in that stock exchange before making public offer. Before, meaning what? When the prospectus is issued to the public on that date, you should have already obtained permission for the securities being dealt with. Please understand, it's very important. First, you go to the stock exchange, get them to agree. They agree. Then only you go public. The reason is obvious now. See, many rascals, what they will do, they'll go for public offer. They will get the money also. They will allot the share. Then they will not be able to list it for some reason. The stock exchange may not be able. Then what happens here? So why did I apply for these shares? Because they are going to be listed. So unless stock exchange permission is there, don't even come. Also, in that prospectus, you should state the name of the stock exchange. Okay. See, the earlier provision, you are allowed to issue the prospectus and make the application simultaneously. And sometimes there used to be big issues and all. Stock exchanges will refuse to give permission. So they said, SEBI said, that's it. New law has come now. Please see to it that permission is obtained before you make the public offer. So prospectus shall state the names of the stock exchanges. So now in India, we have only 2 stock exchanges. Stock exchange is a market. In fact, it is called mandi. Mandi, in Hindi, mandi is market. Am I correct? Sandai. In Tamil, we say sandai. Okay. Sandai is basically, in English, it becomes shandy. Okay. Shandy is basically a European pronunciation of sandai. So these guys, when they came to India, they came, hi, what's happening, man? Oh, that's a sandai. Oh, shandy. Okay. So that's how the word shandy came. Then of course, you have your mandi in Hindi, which all means only market. So market was, what do you do in the tomato market? Yeah. Buy and sell tomato. What do you do in stock market? Buy and sell shares. That's all. There's no great secret here. So buy and sell shares. Which share? Any share. All the companies which are listed, you can buy that share, sell that share, play class. Look at them. I know people, the morning they'll go and buy, evening they'll go down, they'll come. That's all matter over day trading, they call it. Okay, they like to do it. Crazy fellows. I don't know why they do it. Anyway, so I keep looking at them and asking, what are you doing? So I'm in stock market, sir. I'm a stock market. Great people, highly intelligent. Okay, now the prospectus shall state the name of the stock exchanges. I'm sure you are aware that there are 2 stock exchanges. One is called National Stock Exchange. The other is called Bombay Stock Exchange, abbreviated as NSE, BSE. National Stock Exchange, NSE, BSE. NSE is a new entrant. BSE is pre-independence. BSE was formed before India got independence. Very old institution. In addition to that, there were other 22 stock exchanges in India. All the stock exchanges now closed because no need. Today we are having electronic trading. Everything is in the computer. Sitting in my office looking at my screen, I can buy and sell shares on NSE or BSE. Even you can do that. You can open an account with, I'm sure all of you have also. I'm a fool. I should not be telling people like you about buying and selling shares. I'm sure you're doing it on a regular basis. So the point is, that is stock exchange. Okay. Then, so the issue proceeds, meaning what? Listen to me. Issue proceeds. I'm explaining. The money which is raised through the prospectus. The money which is received by issuing the prospectus, that is called issue proceeds. Okay. That money should be retained in a separate bank account. I told you now. And shall be used only for adjustment against allotment where the securities have been permitted to be dealt with in the stock exchange. In case the stock exchange does not allow listing for some reason, repayment, okay, you have to repay that money, right? Now, suppose I'm a very smart guy. What I do, in the application form, where the applicant is signing, I put a small print which says, even if the stock even if the shares are not listed on a stock exchange, even if the minimum subscription is not received, I agree to accept the shares allotted to me. If you put such a condition, that poor donkey may not even read it. He may sign because he's in a greedy hurry to buy your share. So he will sign. Even if such a condition is there, that condition would be void. Rather, a waiver of the above condition by an applicant shall be void. See, applicant is waiving. He's saying, it's okay, yaar, even if you're not listed, even if you're not receiving minimum subscription, I will take. He doesn't know. It's in small print. Fellow doesn't read anything. Simply show me, give me, sign, take it, allot the share. So, even if he has unknowingly waived, even then, such a waiver will be void. Meaning, you cannot later on go to him and say, no, you only agreed on. Sorry, sir, that part of the application is void. You have to return the money back to him. See, once something is void, no legal effect will be there. No action can be taken. Okay. Good. So, okay, I'm going to do one more thing here, because earlier there was punishment by way of imprisonment. Now that punishment has been taken off. Just give me 1 minute. Yeah, I'm going to just remove this off, because in an earlier session I had it only because it was new and many people don't know. So there was a doubt as to whether it will be there in the exam, blah, 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 like that. So I said, better you teach both. Now it's not it. Now this is how it is. No imprisonment, only fine. 5 lakhs to 50 lakhs and the officer 50,000 to 3 lakhs. Somebody had that brilliant doubt that day, whether it is possible to increase this 3 lakhs. No. Whatever is stated here is upper limit. But mostly what the RD will do, he is given that freedom, the ministry is given the freedom to help you. So instead of going for the highest level, they may go for the lowest minimum level. So that is why they are giving minimum. Depends on who that person is, real intention. So they will, even then minimum penalty is 5 lakhs, nothing below that. Okay. So ABC Limited issued a prospectus in April 2020. Please don't ask me to give you a break. I will give a break around 7:40. I will give a break around 7:40. ABC Limited for public issue of shares. It had applied for listing of shares in 2 recognized stock exchanges, and both of them have given permission for listing in June 2020. Wow, that's good. They've given their permission. Can the company proceed for allotment? No. Be careful. Though the permission has been given, it was not given before. I kept on telling before. So here it is given after. The company cannot proceed for allotment of shares. What to do? Refund the money, go another fresh prospectus, collect the money? No allot. That is the only way. See, that is why, friends, you have to be very careful while dealing with these matters, legal and financial matters. You have to be very, very careful. See, in the other sessions and all, we spoke about underwriting. Underwriting like that. What is underwriting? I'm sure some of you in your +2 or college, I don't know, your direct entry, whatever, CPT, I don't know. You might have heard of this underwriting. Whenever there's a public issue there are 2 possibilities. One is, suppose I'm issuing 2 million shares. I may get application for 3 million shares, 4 million shares. in which case the issue is oversubscribed. In fact, there are many issues 10 times oversubscribed, meaning I'm giving 20, I'm only issuing 2 million shares. Public are applying totally for 10 million shares or 20 million shares, 10 times oversubscribed possibility. Then no problem. I have to do pro rata allotment, blah, blah, that you know. So 2:20, na? So 1:10. So for every 10 shares, you'll get 1. Suppose you've applied for 100 shares, you'll get 10 shares, like that. Whatever pro rata allotments are then. Or lot will be there. So they will take 20 applications and randomly select one. SEBI decides. Who decides? SEBI decides. SEBI and the merchant banker, who is your lead manager. These two guys together sit and decide. Of course, the directors also will be involved, but finally it is SEBI. What SEBI says is final. And this category 1 merchant banker just will be shivering with SEBI, because whatever SEBI says, yes sir, no sir, because the minute SEBI's fellows get angry, they will cancel this fellow's license. First thing they'll do is they will cancel the merchant banker's license. Okay, so that fellow will be saying, so no, whatever SEBI says, you agree. Maximum, what he will do, he will use his friendship with these people, relationships, sir, please, sir, like that. Beyond that, you cannot play with SEBI and all. But if you think SEBI has done something which is contrary to the law or exceeded its powers, etc., then it's a government. So that way you can go on a writ to the High Court. But other than that, even if you do that, you are in trouble. Yeah, better comply. Better, because after all, what is the goal of SEBI? The goal of SEBI is to ensure that the public is protected. So comply with it and say, show your sincerity, show your honesty. They will be more than happy to help you. Okay. So there could be oversubscription. That is good. But suppose I issue 2 million shares. Okay. But I'm not getting 2 million. I'm getting only 4 million shares. I'm getting only 2 million. I'm getting only 200,000 or 300,000. Undersubscribed. Minimum subscription not received. What to do? I have to refund the money back. So can I protect myself? Yes, I can. How? By approaching a broker or a guy called underwriter. Now this underwriter, what he will do, he will take my shares. In case the issue is undersubscribed, in case applications are not received for the entire issue, for all the shares, then to the extent it is not applied for, to the extent the shares are not applied for, it is called devolvement. D-E-V-O-L-V-E-M-E-N-T. D-E-V-O-L-V-E-M-E-N-T. Devolvement. The devolvement is there, then these fellows will have to take it. They have to pay and take. So that for me, no problem. They will take, then I can go on with the allotment and I can proceed with my life. My project can go on. So in a way, underwriting is like a insurance. So when there is an uncertainty, you go for underwriting. Underwriting is not compulsory. SEBI has not made underwriting compulsory. If you think there is a possibility that your issue may not be fully subscribed, then you have to go to underwriter. Obviously, the underwriter will not do this free. So they will be charging a commission on the price of the share, on the share price, the price at which the share. So if I am issuing a 10 rupee share for 350 rupees, I have to pay commission on the 350 rupees per share into number of shares to it. This is a huge income. In case there is no devolvement, in case oversubscription, then the entire underwriting commission goes to the pocket. Enjoy. But in case there is a devolvement, then we have to take the share. It is like an investment. We'll hold it. Maybe it could be a fluke. At the time of public offer, there was a bad market condition. Maybe 1 month later, the market picked up. Then I can sell these shares at a slight profit and get out. So basically, the underwriters are financially sound people. They are, obviously, they are brokers. You see, the Taravani Walas, the Mandi Walas, Dalals, they will be the guys who do this. They have a lot of money. They simply, okay, this issue, tobacco limited issue, I will go underwrite. Even if it does not go, it's okay, man, buy it and put it. We'll sell it later. Suddenly, tobacco, some newspaper fellow will write a big write-up on Tobacco Limited and say, Tobacco Limited is going to be the next big thing in this, blah, 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 like that. He'll write, immediately price will start going up. Then, at that time, you sell and we get out. Suppose there is an interest element there, na? It's okay. To that extent, I'm getting commission also, na? So, Danki Dini, it will go off. That's all. That is the end of it. But if there is a oversubscription, straight away to my pocket. Suppose in 1 year, I do 20 or 25 underwritings, 2 are devolving, huge profit now. And even there, I might not lose. Or even if I say I lose a little there, even then, it will be a huge amount for me. So this is the logic of underwriting. I have explained this to you in detail so that you will understand how it works. That is not relevant from the exam point. Not relevant. It's good to know the background. If you don't know this, you will be reading without understanding what it is. So underwriting. Who are these underwriters? They are brokers only. The stock exchange brokers only. They will do underwriting also. See, that is their job. Yeah, day in and day out. Make money. That's all. That's what they do. Lose money, make money. That's all they know. Okay. So, but what happens is the company law says there should be a limit, ceiling on underwriting commission. That is all. Rule 13 only prescribes a ceiling limit on underwriting commission. You cannot pay as much as you want. So, the maximum is for shares. You can pay 5% of the price. Price, P-R-I-C-E, not face value, price at which the shares are issued. Or in case your articles of association is prescribing a rate. Suppose in your articles, there is a clause, section, which says the company is authorized to pay underwriting commission on shares to the extent of 4%. Then 5% or rate authorized by the articles, whichever is less. Please remember, whichever is less. This could be a multiple choice question mark. They could give you an example and ask you which is the correct one. You have to write it. Same thing in case of debentures, it is not 5%, it is 2.5% on the price or what is specified in the articles, whichever is less. Okay, fairly simple topic. Now you know who is an underwriter, etc. When you come to minimum subscription, you will further understand this. Also, in the prospectus, you should disclose the names of the underwriters, the commission to be paid, etc. Number of securities. Suppose some securities are not offered to the public. Let us say that they are taken by the promoter himself. The promoter himself takes a portion. That part of it, no commission shall be paid. Okay? Already there are people to buy now, so no question. Similarly, copy of contract for payment of commission should be delivered with the registrar along with prospectus. Okay? For payment of commission, the underwriting contract that should be delivered with the registrar. Again, I am repeating, in case you have a doubt, don't ask me unnecessarily. Underwriting is not compulsory. If you want, you can have. Otherwise, no need to have. See, if your house, you might have insured for fire. You may not have insured. If you want, you can. Otherwise, no. Ashwini, I was explaining so much background so that you will understand better. See, what you are telling is different. Underwriting commission is commission given for taking up shares in case the issue is not fully subscribed. In addition to this, brokers will also get commission for selling the shares on behalf of the company. In addition, underwriting commission, your example is different. That is called normal commission. So, broker will sell when they promote. Through them, if the application is coming, they'll get some commission. That is different from underwriting commission. Have you understood, madam? Ashwini, GB, have you understood? Yeah. I told you, don't tell me break. Please don't. I generally don't like students asking for break to me. Because when interestingly that subject is moving now, I will get unnecessarily troubled. Think about it. I am talking continuously for 1.5 hours. Don't you think I will be tired? Am I asking for a break? Lokesh ji? For this itself, you are becoming break. You have to write exam for 3 hours. Nobody will give you a break. There, you are doing CA. Don't get these words from my mouth, Lokesh, or anybody. The minute you ask for a break, no, I will think, what these people, for this itself, they are getting tired. How they will write my examination, how they will pass this exam like that, I will start doubting your capability. Don't do that. Huh? I will give break. Don't worry. As a teacher, I know when to give the break because the topic has to come to a logical halt. You can't just like that. Even a bus driver now will have a stopping to stop now. Just because you want to get down, I can't stop the bus. Wait. I'm not preventing you from jumping out. That's always your call. If you're feeling very tired, you go. But little wait. I know, Lokesh, what I told might have been a little thing. Similarly, don't tell no need for break also. You don't decide is all I'm telling. Okay. As a student, don't decide what has to be done. Your only job is to listen to me. When I want to stop, I will stop. When I think yes, time has come, let me stop. Like I know, trust the teacher, ma. That good old Indian tradition, when you are all going to adopt, trust the teacher. Teacher knows. Without, he will not trouble you. Okay, he will not. And see, think about it. Karna was sitting with Parshurama was putting his head on Karna's lap, and spider. So, okay, sort of. It started biting Karna's thigh, and it went all the way through and came out of the other side, and he was bleeding, and Karna was willing to put up with it. He just simply kept quiet because his guru is sleeping like that, and Parshurama woke up and he saw the blood. That again caused problem for Karna because he said, "Hey, you are not a Brahmin, you are a Kshatriya because you are able to bear this pain." That means that. So that point I'm trying to make is that is the type of endurance that a student has to build in his body, the body and the mind. Of course, I'm very old-fashioned. Maybe I'm not the type of teacher for you. Maybe you need teachers. Friends, let's have a break now like that. I am not that type of teacher. Anyway, I'll finish this and then we'll go. That's all. Now is a good time for me to give a break. Take 5 minutes break, go and come. But 5 minutes is it. And come back. We have to continue with allotment of security, allotment of shares and all that. Then misstatement in prospectus. Okay. Yeah. Was it a scorpion? I don't know. Maybe. I've always understood it as, in Tamil, we call it silandi. Silandi. I don't know what you call it in the Hindi or English. Silandi is basically spider. So, vandu, silandi. Anyway, it doesn't matter what insect it is. It is the point of the story is the endurance. The endurance. Chalo, have a break. Sir, break, sir. Come back from your well-deserved break. And one question is there from Tunishka, how the promoter earn money through OFS? See, what is OFS? Basically, promoter is selling. Promoter will have some shares in the company. The promoter will have some shares in the company. Those shares will be sold by the promoter to the public. It's a sale. I'm already having, that will be sold by the promoter to the public. So he would have got it at 25 rupees now. Now he will sell it at 450 rupees. That capital gain. So in other words, he has grown this business, created value now. That money he will now get out of that business. Other people will pay for that. So that extra money that he has generated, the value that he has created, he will now encash and take it out, for which there will be a capital gain tax. Yep. Okay. So, good. Actually, instead of referring to company law, I'm having the original text of Mahabharata in this room. Vyasa's Mahabharata. I keep reading it occasionally. I'll have to check out. So whether it was a spider or a scorpion, I'll check out, and it's a good one. See, so whether it was a spider or a scorpion, I'll have to check out the original Mahabharata text. Then we'll know for sure whether it was a spider or a scorpion. But as of now, don't bother. See how we are interested in the small things, but we miss out on the big principles and the big philosophy that is the background, but we are more worried about the small things. I mean, this is something very peculiar of human nature, that we are worried about the small things. We leave out the big things. So half the time, we are worried about petty things, small things. It doesn't. Principle is lost. No problem. Let it be scorpion only. For the purpose of underwriting commission, does price include share premium? Yes. Price includes always security premium included only. Because face value will be 10 rupees. Everything else is premium only. So together it is called price. So when I say 250 rupees, it means 10 rupees face value plus 240 rupees premium. That is included. It includes the security. Okay, good question. I hope you got it. Now we go on to allotment of shares. So what is allotment? Basically, allotment is the appropriation, means adjustment of a certain number of shares hitherto unappropriate capital of the company. Too much English. See, basically, allotment is making fresh issue. That's all. Okay, simple language here. Allotment is making of fresh issue. Hitherto unappropriated capital means not issued. So we are issuing fresh shares. Unissued shares are being now issued by the company by way of allotment. Popularly, allotment of shares in a public issue is also known as primary market. See, when you apply for shares in a public issue and you buy it, it is said to be obtaining it in primary market. When you go to the share market and you buy it from somebody else, it is called secondary market. It is called secondary market. Okay. But offer for sale is an exemption. Means in offer for sale, it is not hitherto unappropriated capital. It is already shares allotted to the promoter, which the promoter is selling. But still, the whole thing is coming in one package. So even offer for sale is primary only, primary market. But the transaction is sale. But when after that, once the public issue offer for sale is over, and the shares are hitting the market and listed, thereafter, whenever people are buying and selling, it is only secondary market. It is not primary market. So, at the first time when the shares are made available to the public, it is called primary market, when it is allotted. So, hitherto unissued shares are allotted. Now, what you may want to understand, hitherto means up to now. Hitherto means up to now. So, shares which have not up to now been allotted, means issued, are now issued. That is called allotment. Okay. Or being appropriated. That means are being identified as belonging to somebody. See, all along these shares had no owners. Now, at the time after allotment, specifically we will say these shares belong to Ramu, those shares belong to Mohan, like that we will allot. That is called allot. So we will appropriate a certain number of shares up to now, which has not been issued by the company, will be now allotted. So if you don't like hitherto, then you use up to now. The legal principle is based on offer and acceptance. Friends, you already know this. Okay, we studied it in Contract Act. Only reminding you, the prospectus by which the shares are issued is an invitation to treat. It is not an offer. The prospectus is not an offer. Though loosely we'll say shares are being offered and all, still prospectus legally is not an offer. It is only an invitation to treat. The application made by the subscriber for shares is the offer. So the first time when the application is made, the applicant is making an offer. The board of directors is going through the offer and allotting the share. Allotment by the board of directors is the acceptance. So offer plus acceptance, consideration, contract. So basically, owning of a share in a company is a contract between the company and the company and amongst the members inter se. Those people who signed the memorandum for the first time have entered into a contract. Subsequently, every subscriber is again entering into a contract. Got it? So every time. And allotment, contract completed. Now you are bound. You sell, then you are going out of the contract. Somebody else is coming in. That person will now apply. That's when next chapter, share capital and debentures, we will talk about transfer of shares also. There we will talk. That is when A is selling his shares to B, B will now become the new owner. He is the transferee. He has to send an instrument. There's a form for that, share SH form, SH7. That has to be sent to the company to ensure that his name will now be entered in the register of members. So that contract with the old member will be out and the new member will be created. This you will come across when we come to transfer and transmission of shares. But this is the beginning. The shares were not belonging to anybody. But when the application came from the public, they were then allotted, meaning fresh shares, the new shares have been allotted, unappropriated capital. See, in offer for sale, there is no allotment. Because in offer for sale, these shares have already been allotted to the promoter and other people. They are only selling it. So it is not. But still, offer for sale and prospectus will go together. All the rules applicable to prospectus will apply to offer for sale also. Okay. This whole concept of offer and acceptance was laid down in a famous British case, Ramsgate Victoria Hotel versus Montefiore. Ramsgate Victoria Hotel versus Montefiore. You might notice, whenever I give a case law, I will not mention that 1929 AC 158 and all that. I will not mention. If you want, I can give it to you. If anybody is saying, Mr. Srikanth, that is called citation. See, in your Board of Studies material, page number 3.11, you will see in the bottom, they would have given a superscript for Nash versus Lind. There will be 11. That 11 will be down. There it will be 1929 AC 158 bar 140 LT 146 HL within brackets and all. Should I remember all that? No, sir. Please don't waste your time, Baba. Please don't. There's no need for you to mug up that amount. Okay? Don't waste your time. If you ask me that question, I'll categorically tell you. Boss, if you write all that, you'll straight away, they'll give you a doctorate in law. Straight away. Of course, this idiot used to remember that also once upon a time. But then, no need. There's no need. I used to write. In fact, one of my college professors said, Mr. Srikanth, why are you writing all these things? But sir, it is there. I remembered it. Please don't do that. It's a waste of time. Like that. Then only I realized that it did not be written. Okay. Why is it there? Because, when it will be relevant. Suppose I am appearing before the Commissioner of Income Tax Appeals. And I am telling him, sir, Calcutta Chemicals Limited versus CAT, one case is there, sir. a Bombay High Court case like that, if I say, is it so? Can you give me the citation? So, yes, sir, it is in Taxman, sir, 21 Taxman, sir. Please refer to Taxman, 21 Taxman, 22 is there, sir, like that. Or better still, I'll give income tax reporter citation. Sir, it is there, sir, in 300 ITR, 554, it is there, sir. Just go and have a look. So that means what? In the 300th volume of the reporter, in page number 554, the case law report will begin in that first page. That first page will be given. If I don't give the citation, how will he know that such a case is there? I may be giving some nonsense. So I'm preparing a brief, when I'm preparing a submission for the CIT appeals or tribunal, there I will mention clearly. In fact, I'll give the citation, I'll give the link. Sometimes what we do now, since it's online uploading, we give the link also so that they can actually go and read that. They want. So today, we got direct links with the Taxman website. So they also have Taxman. So simply you give the link, they will go and find it. Not a problem. Just I'm giving this background to you so that you will understand whether to report or not. Some of you may have a doubt. Should I remember all that numbers and all that? No need. If you can remember the names, it will be. Nash versus Lind. Ashbury Rail Carriage versus Rish. Royal British Bank versus Stockton. You can remember that now. What is it? Erlanger versus New Sombrero Mining Company. Why not? Okay. Now we come to minimum subscription. Friends, minimum subscription is the minimum amount to be collected or the minimum amount to be received as subscription. Means now currently today it is 90% of the issue size. 90% of the issue size. What happened? How many shares did we allot? How many shares did we give? We gave 2 million shares prospectus, 1 million offer for sale, total 3 million, 90%. How much? 2 crores, 2,700,000. That is the minimum subscription. So minimum I should get application. Minimum I should get application for 2,700,000 shares. Got it? 2,700,000 shares. Let us say that I'm issuing 10 rupees share for 350 rupees. 350 rupees. Am I correct? So 350 rupees. Then how much, when should that 2,700,000 into the application money, when it should be received? It should be received within 30 days of issue of prospectus. From the day the prospectus is published, made public, within 30 days, I should get 90% of the issue size. Only then minimum subscription has been received. Otherwise, minimum subscription has not been received. That is why underwriting. Now are you able to link it with underwriting? My dear friends, link it with underwriting. See, why underwriting? Because I'm afraid. I'm Dubakur Limited. I don't know. See, I'm not Reliance Industries Limited. I'm not Honda Hero Limited, Hero Motors Limited. I'm Dubakur Limited. Suppose public know about my background, they don't subscribe, what to do? So I go to the underwriter. Then the underwriter looks at my prospectus, looks at me up and down, then says, Dubakur Limited, okay, 5%. No, sir, I can't pay 5%. Our article is only 4%, but I can pay only 3%, like that. Negotiate finally to, okay, 3%, go. So 3% you have to pay the underwriter. In case the subscription is not received, 2,700,000 not received, then I get only 2 million or I get only 2,500,000. Then the balance amount, that is called devolvement. The fellow will have to take. In fact, in your accountancy paper, in those days, I don't know, maybe in CPT you might have done it on calculation of thing. Yeah, I will clear it. Manish, just give me 2 minutes. I'll have to complete the topic. Then I will definitely do it. Don't worry. So don't ask me to do something when I'm doing something else. I'll finish this and I will definitely take a test. So again, on this 350 rupees now, I may not collect the entire money in one shot. But usually today, 95%, why 95? 98% of the cases, the entire money is collected at the time of application. The entire money is collected. But 1 or 2 cases, at the time of application maybe. Even then, that application money cannot be less than 5% of the nominal amount. Meaning, application money cannot be 5% than the nominal value, which means 5 rupees minimum you have to collect. 10 rupees share, 5% minimum you have to collect. The nominal. So this is called minimum application amount. Okay, but usually they collect the entire amount in one shot. Okay. Once you have made the allotment of shares, you have to file a return of allotment, details of the allotment, who are the names of the person, how many shares, etc., etc., in Form PAS 3. Form PAS 3. Now, PAS is Prospectus and Allotment of Shares. PAS 3. Friends, this will usually not be done by the company. When they go for a public issue, there will be a lot of people doing many, many things. One of those guys would be called registrars to the issue. There will be a private agency who would handle the whole issue. They will receive the application form, they'll punch it, they'll create, then based on SEBI and the Category 1 merchant banker's instruction, they will make the allotment, give information to the DP, then the DP will credit those accounts. Everything will be done by this registrar to the issue. Thereafter, they will also handle the register of members. Whenever there's a transfer and transmission, they will also act as share transfer agent. So it's outsourced service. In those days, today you have Cameo, is a very famous brand, service provider who does this. CAMS, CAMS, CAMS. You had Carvey, KRVY, maybe you remember Carvey, they are also there. They are not there now, but so like that, many companies are there. Usually these companies now will also have broking. They will also have DP, everything they'll have, but some companies will have only registrar. They will do that. So these that registrar to the issue, they will file that form PAS 3, okay, with the registrar. That is one of the jobs that they will undertake to do. Where shares are allotted for consideration other than cash. So in some cases, instead of giving money, a person may give some asset, a land or something. So we may allot for that. In those cases, there will be a contract between us and him, by which he will agree to transfer the asset and we will agree to allot shares. That contract should also be attached to the form number PAS 3, right? Actually, that CAMS is the expansion is Computer Age Management Services. I think Computer Age Management, very old company. CAMS is a very old company. CAMS, CAMS. You can check out. Cameo is the Chennai-based company. Very good, very wonderful company in the SPIC group. A very, very straightforward company. CAMS. Carvey, there was some scam, actually. I forget what, but Carvey had a scam. Okay. So, now, this is just a logical flow, thought flow diagram. So, allotment of securities can be done only if minimum amount is subscribed and the application has been paid and received by the company. And application money should not be less than 5% or such other percentage prescribed. Agreed. If the minimum amount is not subscribed or the application money is not received within 30 days from date of issue of prospectus, or maybe such other period as specified, because you can go to the SEBI, maybe little extension they give you, whatever it is, if it is not received within that time, the amount received shall be refunded within 15 days, the entire amount, which is why the money received on the public issue will not be kept with the company, will be kept in a separate bank account. You remember that? Will be kept in a separate bank account and will be refunded, right? You remember here, issue proceeds shall be retained in a separate bank account and shall be used only for adjustment. Repayment of money in case allotment cannot be made for any reason. Got it? So you cannot refuse. It will be kept. See, blindly the banker will simply send it back. No question of company coming and telling anything. Just go, get out. Money will go back. See, today SEBI has ensured that investors' money is protected. Unscrupulous promoters and directors and frauds maybe they will discover some new method of defrauding, etc., etc. But as of now, the controls are very strong. See, every day a new sucker is born there. See, Nobody cheats a person without his permission. Nobody can cheat a person without his permission. If somebody is getting cheated, it is because they are taking that risk, which normal person will not take. These fellows are taking. But okay, even those idiots are protected by SEBI. Can you imagine? Even those idiots who will not think before doing things, who will be greedy, even they are protected by SEBI. Can you imagine? From their own foolishness. Correct. Money will be kept in an escrow account. As usual, if there is any default, if you allot it without all this, then 1,000 rupees for each day, or if you don't refund the money, in case of default, up to 1 lakh, you have to pay. This refund of application money is also very important. You have to refund it within 15 days. Beyond 15 days, okay? If you do not repay, if this money is not repaid within that period, the directors of the company who are officers in default shall jointly and severally be liable to repay that money. Not the company. Please note it, my dear friends. The company is not liable. The directors and officers in default shall jointly and severally be liable to repay that money with interest at 15% per annum, which is huge, killing interest. Because today the bank interest itself on loans, is only about 8.5 to 10%, maximum 10. Okay. Whereas FD interest is 7, maximum 9. Right, senior citizens, blah, blah, for 444 days, and all this, Equitas Bank may give 9%. That's it. Where is 9%? Where is 15%? Where is 10%? Where is 15%? Yeah. So, huge amount. So, the application money to be refunded shall be credited only to the bank account from which the subscription was remitted. Okay. So, now we move on to another topic, which is called misstatement in prospectus. See, idea is, the prospectus is issued to the public. Public consists of people like you who are highly intelligent and people like me who may not be knowledgeable. Okay. So when I look at the prospectus, I may not understand many things. So I may simply buy. Or I may read it and I might believe it. Suppose the prospectus contains statements which are misleading, which are false. And I honestly see, after all, boss, you are all big shots here, directors. I am Aam Aadmi sitting in my office. I don't know anything. I see. I know only one thing. My brother-in-law told me, buy Dubakur Limited shares. That's all. Dubakur Limited, wonderful company. So I went through Financial Express. There are also some donkeys writing Dubakur Limited. Risk-taking punters may look at Dubakur Limited like that. He will read. I don't understand what he means by that. Whatever it is, one thing is clear. Dubakur Limited is a good company according to my brother-in-law. So I read the prospectus. There, all sorts of false statements are given. I believe it. Then I apply for the shares. Later on, I find that nothing is true. So then I should be able to get my money back. Not only that, I need to get some compensation for the interest and my mental agony, the sadness that I undergo because of this pressure, my hard-earned money, boss. So somewhere the law has to protect me. And this protection is given through the Companies Act, through the sections. Okay. Now, Suganya P wants to know what is an escrow account. I will tell her what it is. See, if some money is to be kept separately till the performance of some duty, then that account or that method is called escrow. So, suppose somebody has to comply with certain conditions. Until they supply with the condition, they cannot get that money. But they might say, hey, I will comply with the condition. Suppose you don't pay, what I will do? So I tell him, boss, your money is safe. I put it in that account. See, I got a confirmation that money is safe, but you cannot touch it. You finish this, for example, I'm having a contract with the builder now. See, so the builder he has already completed. Now he comes to me and says, Mr. Surikant, you have to give me 25%. I said, I can't give you a pie. You still have to finish. Finishing work is still going on. See, this is a list of things that you have to do, Baba. You do everything. My engineer will come and inspect it, Baba. Once he gives me the clean sheet, everything is correct, then this money, I can give you 25%. Then he will say, hey, Mr. Shrikant, I will do it. Then if you refuse to pay 25%, what I will do? I said, look here, don't talk like this. Your money, na, So I will call my banker and tell him, sir, open an account in my name. Keep this money in that account, but don't issue unless I tell you. But or rather, open an account in his name only, but don't issue unless I tell you. Got it? So that if I say no objection, you send it to me. So that money will be kept by the bank in a separate account called escrow. And in case this fellow completes everything correctly, NOC will be given by me, money will go to him. Otherwise, money will not go to him. I'll get it back. So my money will be safe. For him also, he knows that money can be taken by him, provided he complies with all the conditions. So in this case, what is the important condition that the company has to comply? Minimum amount subscribed. Correct? Application to the stock exchange, and that should be approved. Listing should be done. So once everything is done, that's it. My money is mine. I can take it. Till such time, it will be kept in an escrow account. Okay. Have you understood, Suganya? I have explained escrow account. Have you understood it? Okay. If you still have some doubt, now you go to Google and you put escrow account. 100 definitions will come in addition to mine. See, use Google not only for entertainment, not only you, Suganya. I'm telling for every student here or every youngster listening to me, the internet is not only for playing games. It's not only for reading news. It's not only for Facebook, and it's there for that also. But it is like as if an entire library is at your fingertips. Imagine in my library in this building where I'm sitting, in my second floor, I have 23,000 books. I have 23,000 books in my library. I have more than 200 dictionaries, 200 types of dictionaries, different dictionaries. Okay. But you know what? All this 23,000 books, 200 dictionaries, no need. Karlo dunia mutti mein. Everything is in my hand now. If any word, if I don't understand the meaning, I don't have to go and beg anybody. My knowledge is in my control. I simply can go to the internet, Google. I will type in Google, what is escrow account? This donkey Srikanth, he's explaining, but I cannot understand. Google can teach you. So many, and Google won't teach you. People like Srikanth would have written articles, would have given definition. That will be coming there. Okay. So still, somebody like me explaining is good, but I'm only telling you going forward, your knowledge should be collected from every source. Don't expect only teacher will give knowledge, book will give knowledge, board of studies material will give knowledge. No, knowledge is everywhere. Pick it, you will get it. Okay. This skill, if you develop it, you will become a successful chartered accountant. Being successful in the examination is one thing. Becoming a successful chartered accountant is another thing. Becoming a successful engineer, becoming a successful doctor, that is different. For that, this ability will be very, very useful. Of course, you are all students at a very primary level, intermediate level. You are entitled to ask the teacher to define words, and the teacher also, while teaching the subject, technical subject, should define. But still, I am humbly suggesting to you, start exploring this facility in Google, by which new words, technical words can be learnt by you. Once you look up escrow, you will link it with SEBI. You will link it with Scratch. So many ways you will remember, and it will be easy for you. This is my humble suggestion to you. But if you still think, no, sir, you are the teacher, sir. You will only teach me, sir. In case I have doubt, means I will ask only you, sir. Then you are restricting the source of knowledge. That's to one man or one individual. Whereas the whole world can be your teacher. Jagat yasya guruhu saha. You can become the person who will learn from the entire universe. Why you are only learning from one man? You can learn from I am a person who learns from the whole universe. The whole universe is continuously teaching me. Can you imagine this? So I'm sorry, I know I'm being a little emotional here, but some of you should think. In fact, when I mentioned 23,000 books, you don't have to read the citation of case law. That's what I told you. Now you are asking like this, Tunishka. No, don't have to waste your time reading citation. How to read? You read like this. 1929 AC 158 bar 140 LT 146 HL. Okay, that's all. No need to remember. I'm telling now. Please don't waste your time. See, Rutraj Homanmane is very excited about 23,000 books. Boss, I started collecting books from when I was 12 years old. Okay, so now my son, when we went to law college in Bangalore, he started collecting from Bangalore. He's got about 200 books. Already he's got his own library, which is now getting merged into my library. Okay, so and in Coimbatore, I have another about 200 books. So what I'm trying to tell you is I'm a crazy, voracious reader of books. That is my mistake. Reading books, all wasting time and all. What to do? I waste time reading, developing knowledge, thinking, questioning, not believing what I read in the internet or in the newspapers, finding out for myself. All these foolish things I keep doing. That is my mistake. I should also become a slave. Whatever is I see in the internet, news and all, news reels and all, I should believe. Whatever is told in WhatsApp, I should believe. Whatever is in the newspaper, I should believe. Sorry, I'm not able to do that. Chalo. One question that people ask me now, Shrikant, you are saying you are having 23,000 books. Have you read all of them? Not all. Obviously, I have not read the encyclopedias and the dictionaries and some of the reference books. But other than that, yes, I have read almost all the books. Almost about out of 23, I read about 15 to 16,000 books over my lifetime from when I was 12 years old. Yes. Not immediately. From 12 years old, I have been reading. Chalo. The idea is not to bore you with all this stuff, but to tell you that knowledge is available everywhere. Know how to access it rather than only expect teachers. And that was there when you were in school, college, etc. You paid a tuition fee. There was a professor. Only that man was the source of knowledge. Not necessarily. Even in college, we could refer to other books and all. But in fact, many professors used to be afraid of me because I would come out with new ideas. But still, my only humble suggestion is, look at once at least. This man is telling so much now. Once you go to Google, just type escrow account meaning. Immediately you will get. Then read it. Just 2-3 minutes. If you have a notebook, a little bit of notes you make. See the level of your improvement in your knowledge day by day. Suddenly you will become knowledgeable. You will become fluent in English. You will be able to write answers fluently. All that will start happening. Okay. Believe me when I say this. Okay. And most of you in the age group of 19 to 26, assuming that this is the broad average age gap, 19 to 26, you have got time to do all that. Your life is ahead of you. Okay. If you don't do it now, when you will do? Then you will become CA, get into a job. Then you won't have time. Now is the time you have to do all these things. Okay. Chalo. Now, quickly with the remaining 10 minutes, I thought I could finish misstatement. It's not going to happen. That's okay. So, prospectus is an invitation to the public for subscribing to securities. Right? So, we are making a statement to the whole world. Therefore, every statement made therein should be true and correct. Okay. So, making a false or incorrect or inaccurate statement is a misstatement. Okay. Omission of material facts would also be a misstatement. Because telling the untruth is one thing. Not telling the truth is also there. Am I correct or not? Omission of material facts. See, father is looking for a groom for his daughter. He goes to the village. He meets a person near the village well, generally asking how is that family. That fellow, that local wala knows about that family. The crooks number one, that groom is a drunkard. He knows. But still what he does, keeps quiet. They are good people. Wonderful. Like that. That is omission of material facts. Later on, this poor father, believing he gets his daughter married, then only he realizes, this fellow is a drunkard, like that. So, omission of material facts would also be a misstatement. Okay, is the point. Similarly, you have something which we call ardha satya. Ardha satya means misstatement. Again, to give an example from the famous example from the Mahabharata, Yudhishthir himself was guilty of this. Do you remember? When Dronacharya is there, the only way to hit Dronacharya is through his son, Ashwatthama. So what Krishna does, there is an elephant, real elephant called Ashwatthama. So Bhima goes and kills that elephant. Bhima can kill 100 elephants also. So Bhima kills with his gada, he kills mace, he kills one elephant, that Ashwatthama. And then he comes into the battlefield and with that mace, he shouts, Ashwatthama hataha, Ashwatthama hataha. So immediately Ashwatthama hataha, he says. So people are celebrating. Drona hears that. His Ashwatthama is dead. Then immediately he's saying, no, I won't believe Bhima. Bhima can tell a lie. Call Yudhishthira. I will believe only Yudhishthira. So in the middle of the battlefield, Yudhishthira comes. Imagine, Opposite side guy is now coming and Drona, tell me, is Ashwatthama dead? See, there again he is not asking, is my son dead? He is asking, Ashwatthama dead. So immediately Yudhishthira says, Ashwatthama hataha kunjaraha. So when he is telling elephant, kunjaraha, he lowers his voice. And at that time, Krishna blows the conch, the Shankha. So the sound, Drona doesn't hear kunjaraha, but he hears Ashwatthama hataha. So Yudhishthira himself has told. So he immediately goes into the coma. And after that, this guy Drishtadyumna goes and he cuts his head, but that is later. Already the life has fled from the body. Only a dead body was killed. But the point I'm making is Narova Kunjaro. See, that is whether it is a human being or an elephant. So this is an example of a misleading statement or a misstatement where you tell something wrong to convince a person to do something. So, which is one of the, whenever we talk about Yudhishthira, was Yudhishthira Dharmavan? This is one example. They will say that Yudhishthira was party to a fraud. He was party to a fraud. He was not fraudulent because he told Ashwatthama Hatha Gunjara, but he was a party to the fraud committed by Krishna and Bhima. So, like that, the Mahabharata is a conflicting and continuously confusing narrative, which nobody is good, nobody is bad in that story. Okay. So this is one example I'm giving of misleading statements. Now, so any misstatement in prospectus carries heavy penalties. There may be a civil liability or criminal. Okay. So civil liability is paying compensation to those persons who are affected. See, misstatement in prospectus is a crime against the whole world. So for that, those people who are doing this should be punished by the law. That is called criminal liability. They are violating the law, punished by the law for criminal liability. In addition to that, people have suffered loss now. Because I invested in that company, and then that company got listed and nobody price fell. I've lost money now. I've lost money, mental peace, all that. So I have to be paid compensation, right? So the Companies Act provides for such cases. So they provide for criminal liability in Section 34. Okay. So based on the Criminal Procedure Code, they will be punished by imprisonment or fine and all. Civil liability, where there is a loss or damage. See, let us say that there is a misstatement in the prospectus. There was a misstatement in the prospectus. A bought the share. The share was sold to him at 350 rupees. In the market, that share kept on going up, 500, 600. There was a misstatement. Still, the share price is going up. Where is the loss? Where is the damage? Are you able to understand? So, for civil, but still criminal liability is there because there is a misstatement. For that, punishment will be there. But civil liability, so the court will ask, what is your loss? How much money you lost? Nothing. Then why you are coming, go? So, this is a offense against the counterparty. You made a promise. I believed you. Then the promise is not true. You have to pay me for my loss. So unless there is loss or damage, there is no compensation for civil liability. Got it? So the time is about 8:30. I honestly believed that I could complete this. So I think Rudraj Honmani, I will definitely go through this point you are telling, Narova Kunjaro. Whatever he said, I will definitely go. Okay, maybe he said Ashwatthama Hataha Narova Kunjaro. Agreed. Maybe whatever it is. Good. Going on. Thanks for a wonderful and patient hearing. I know sometimes I go a little overboard and I keep telling all nonsense, but ultimately coverage is important. We are covering and hardly we have. See, actually I could have completed it today. I'm deliberately going a little slow. If I go at my usual pace, today we would have completed. But since many of you need explanation for words also, specific words you need to understand, I'm going a little slow. No problem. I will go slow. Don't worry. One more, we will have fifth. Maybe fifth, we will complete this topic and we will take up, maybe we will take up some other topic on that day. Or by then I would send you an assignment. And in that class, we will discuss the assignment also. Okay? Okay. Thank you. And okay, even I can't make questions. You are explaining. Okay, thank you. So, chalo, good night. Bye. See you. Sir, class over, sir.